Everybody. Hope everybody's having a good Tuesday morning and everybody is staying safe and healthy. Welcome to the North County Estate Planning Council San Diego monthly meeting. We're glad you're all here to join us this morning. We know you have a busy calendar, so we're happy that you're here. A couple of announcements to start. First of all, I'm obviously not Bill Super. My name is David Jacobs. I'm one of the board members here at North County Estate Planning Council. A couple of announcements to start off. Our webinars are always, as you know, on the first Tuesday of the month, but unfortunately, because of COVID-19, we can't meet in person at Fairbanks Ranch anymore, but we look forward to getting back there as soon as we can. We're now offering MCLE and estate specialist credits along with CPE for CPAs, for trust professionals, and for plan giving professionals. And in that vein, we want to thank Dan Wilson and Roberta Robinson for all of their work and assistance to help us with the MCLE front. In addition, we're always open to suggestions for speakers and topics. So if you have any ideas of things that you want to hear about, topics that you'd like to discuss, please email Bill or myself or anyone on the board, and we'll be happy to put that in the mill and make sure that that happens. This morning, speaking of great topics, we're excited to introduce Carly Harmanson of Union Bank and Don Hall-Canine of Canine & Booth. They are going to discuss the challenges that fiduciaries face in this volatile financial and economic world we are now living in. We're going to be looking at some of the issues that have been arising from the perfect storm of the 2020s, COVID, shelter in place, business interruptions, stock market fluctuations. Trustees are being called upon to make difficult decisions about investment and management of trust assets, underlying costs, distributions to beneficiaries, and protection and care of the elderly and incapacitated clients. These issues will be looked at this morning, considering asset diversification, the Uniform Prudent Investor Act, valuation, increasing defaults, increasing requests for distributions, and undue influence. And as usual, we want to thank our friends at the Jewish Community Foundation. They have been kind enough to assist us with these Zoom webinars. Can't thank them enough, especially Ollie Ben and Charlene Wallach. And now I'd like to turn the meeting over briefly to Ollie, who wants to say a couple of words about Jewish Community Foundation.
Well, thank you so much, David. My name is Ollie Ben. I'm the Director of Philanthropy and Social Impact at the Jewish Community Foundation here in San Diego. If you've been a regular attendee since the NCPC meetings went online, you'll have heard some many presentations from my colleagues at the Jewish Community Foundation, Jeremy Pearl and Charlene Wallach, about different aspects of our work. First, Jeremy mentioned how JCF is the biggest grant maker in San Diego and how we facilitated over $1.6 billion in grants since our inception, including raising recently several $1 million in COVID-19 emergency relief funds. Many people don't realize that the vast majority of our philanthropic dollars granted from JCF donors go to non-Jewish organizations here in San Diego and across the country. Next, you'll have heard from Charlene Wallach, who talked about our Trusted Charitable Advisors program for professional advisors, which helps them learn how to have constructive conversations with their own clients about charitable planning, as well as to build their how to build their professional networks. And in fact, our own Bill Super is in our current Trusted Charitable Advisor class, which is very exciting for us. So today, as Director of Philanthropy, I wanted to move from that 30,000-foot view to zoom in on some specific examples of how we've helped professional advisors with issues their clients are facing. And I'll start by saying we provide this service for free. We're always available at the end of the phone or by email to help professional advisors like yourselves. So first is simply when clients want to make large or more complex charitable gifts. For example, we had a client of a financial advisor who wants to make a large gift to a university here in San Diego, but needed to know that the university would actually honor its commitments related to this gift, which was a multi-year process. Because the donations would be coming from a donor advised fund, that creates some wrinkles because, as many of you know, a personal pledge directly from a donor is legally binding. So So we worked with the client and a professional advisor to structure a grant agreement where JCF provided oversight and a reporting mechanism so that the grant recommendations could be made through the DAF, but the donor's wishes to hold the university to its commitments would be honored. So obviously that is a specialty and something where we have a lot of familiarity and sort of taking over that part of philanthropy that most professional advisors don't want to or have the infrastructure to handle. Second, we work with professional advisors where there are either assets or real estate issues that make tax efficient giving more complex. So we've worked with, for example, a professional advisor whose client wanted to gift some real estate into a lifetime charitable remainder trust, where ultimately the remainder would go into a DAF. However, there was a mortgage on the property, and so the donor couldn't afford to pay off the mortgage. JCF actually agreed to be a recipient of a part of the property that was equivalent in value to the existing mortgage. The property was thus split 60% to the CRT, 40% to JCF, which then enabled the property to be sold. Now, there are only specific situations in which JCF would do this for obvious reasons, but it does illustrate how we work with professional advisors to find creative solutions for their clients. Finally, we work with professional advisors on a number of different strategies that you're probably already familiar with. We've partnered with many of you as fiduciaries for gift annuities and CRTs, such as Union Bank and your presenter, Carly. And we've worked on creative life insurance strategies with many of you, such as last month's presenters, John Kramer and Steve Chichester. And I'll just close by saying that planning is key. It's worth having these conversations early with clients, because by the time you get to a buyout or a major liquidity event, might be right, on the horizon, it may limit the tax efficiency of certain philanthropic strategies. So we always recommend planning and starting these conversations around charitable giving early with clients. We're always here to provide free consulting to professional advisors, so feel free to contact us at any time. And with that, I will turn it back over to David.
Thanks, Ollie. I'm also a graduate of the JCF Professional Advisors Program, and it really was a great thing to go through, and I appreciate it and encourage everybody, if they haven't, to go ahead and do that. Thanks again, Ollie, and thanks to the Foundation for your support and for helping us arrange these Zoom meetings. Trifectas have been a new addition to the Council over the last couple of months, and they've been quite popular, so we want to continue those, especially in light of the fact that we can't all meet in person every month. So trifectas, for those who are not familiar, occur after this webinar, and they're a way for professionals that are part of the Council to get to know each other better on a one-on-one or one-on-four basis, typically on a Zoom webinar, so you can get to know other people in the Council a little bit better. If you're interested in participating in a trifecta, please email either Bill or Pete Tentler. Pete is also on our email list. He is a board member, and he also needs volunteers to host those trifectas. Volunteers should be familiar with how to use Zoom. That would be terrific. Some other events that we have coming up at the Council of note. Next month, August 4th, the topic will be planning for the $30 million to $150 million taxable estate, from the basics to the creative to the exotic. And the Council is pleased to have Mark Morris of Levitt Zacks and Phil Sullivan, also a board member here at the Council, to present on that exciting subject. As well, the Council is welcoming on September 1st, Natalie Choate, who is one of the premier IRA experts in the country. She's going to be speaking to the Council for 3 hours from 7:30 to 10:30. Obviously, continuing education credits will be provided. She's going to be teaching on, or presenting on, everything you want to know about planning around IRAs, including new tax law changes. She's going to be offering copies of her new book. We hope you'll tell other advisors that you work with about this unique event. This will be a great way for the Council, I think, to really put its name on the map. We really have a nationally known speaker coming. Looking forward to having you all participate. We also hope to be bringing our hot topics updates back to the Council shortly. We've put those on hold for a little while, but we want to thank Catherine Swafford, Kristen Shepard, and Roberta Robinson for providing those updates to the Council every month. We hope to bring those back. I also want to thank fellow board members, Joe Willett, of course, Bill Super, Phil Sullivan, Carly Harmanson, who's presenting this morning, and Pete Tetler. And speaking of our presentation this morning, our presenters, Carly Harmanson of Union Bank and Don Hall-Kaneen of Kaneen & Booth Law Firm. Carly is a Managing Director, Regional Director, and Fiduciary Management Executive of Trust and Estate Services at Union Bank, the private bank. She works with a team of specialists in wealth planning, investments, risk management, trust and estate services, and banking in the San Diego, La Jolla, Rancho Mirage, and Irvine Trust offices. They help manage a wide range of trust and estate matters in accordance with sound fiduciary principles. She's been with Union Bank since 2002 and is a veteran of the trust business, having over 25 years experience with both personal trust and employee benefit plans. She's a graduate of UC Davis, BA in sociology, and a personal designation in certified retirement services professionals. She also serves the community in many capacities. She's a member of the Rady Children's Hospital Foundation Board of Trustees. She's a chair of the Trust and Estates Committee for the Rady Children's Hospital Foundation, a member of the Friends of Vista Hill Board of Trustees, and a member of the board of Casa Cornelia Law Center. Carly, thanks so much for presenting this morning. Don Hall-Kaneen of Kaneen & Booth has over 20 years of experience representing clients in estate planning, estate and gift taxation, family succession planning, post-death trust and probate administrations, and trust estate and probate estate litigation. Don represents individuals, licensed professionals, fiduciaries, corporate fiduciaries in probate and trust litigation matters. She advises trustees regarding trust administrations, individual and corporate executives regarding probate administrations, beneficiaries regarding their rights in a decedent's estate, and clients in estate planning. She has significant experience working with complex family dynamics, high concentrations of commercial real estate, and unique assets. She uses her extensive litigation experience to identify potential issues and create a strategy for avoiding litigation as she counsels and advises individuals in their estate planning. She is a graduate of California Western School of Law, my alma mater as well, and a cum laude graduate of Bethel University. So please join me, everyone, in welcoming Carly and Don. And Carly is going to start the presentation this morning.
Thank you, David. Welcome, everybody, this morning. It's a foggy morning where I am, so hopefully you all are safe and well. I wanted to start, as we look at our presentation, to let you know we're looking at, Don and I both, some kind of best practices that we've put in place. And I think, as you'll see, because we're going to have a conversation around these issues, that there isn't a definitive answer in some cases. I started, if we can go to page 2, Ollie. Perfect. That with the Uniform Prudent Investor Act, it's kind of our shining guide, if you will. And I think it makes sense, especially in the circumstances that we're in, to start with this and take a look at it. So I think a lot of times we take some of this for granted, but looking at section 2 kind of gives us the beginning of thought process as we look at this, looking at general economic conditions, the effect of inflation or deflation, the tax consequences, the role of each investment, and that's important, and then the expected total rate of return. So it gives you kind of the guidelines and is a good place to start, I think, because staying on top of the value of assets is going to be almost a full-time job for many of us as we move forward. We're all trying to bring the best total rate of return to the trust and do what's best in our fiduciary capacities. So we're all working to make assets productive, and we're going to discuss today that there may not be clear-cut answers for the decisions you need to make. So the process you employ is vitally important. I think documentation and process become our friend and provide protection. So it's really important to take a moment, make sure everything is clean and well documented when you're making some of these decisions, so you don't get criticized later on, because none of us have a crystal ball. So I wanted to also give a shout out to everybody who's on this call today and the North County Estate Planning Council. In preparing for this today, I reached out to a couple of our members to check in with them and confirm what they what they see in the market today. I try and stay on top of the news. I spend a lot of time reading, but there were a couple things I was unsure of. And so one of the things that's important is we have a great group of resources here. And I think a lot of us use each other that way. But I want to give a shout out to the council itself and all its members, just because as we see, we are truly all in this together and we really can help each other. So I think it's important that we rely on each other to do the best we can for our clients. So with that, we're going to let Dawn now talk about real estate.
Sure, Carly, I just had a couple comments before going on to the next slide. When we talk about managing investments, one of the first things a new trustee who steps in will say is, gosh, we're in the middle of a global pandemic. What should I do? Should I hang on to everything? Because the statutory duty of a trustee is to protect and preserve trust assets. Or should I sell in a pandemic? Will I be criticized? And so the first thing we tell new trustees to do is read the trust. Does the trust say you must comply with the Uniform Prudent Investors Act? And most trusts will have direction. And if the trust says you don't have to comply with the Uniform Prudent Investors Act, you may nevertheless choose to do so, because that is an objective standard that if you do comply with the act, will be hard to criticize you, because in breach of fiduciary duty litigation, the standard is, have you breached a duty? And if you have fulfilled a statutory regime for managing investments, it's much harder to demonstrate that you have breached a duty and therefore would be liable for damages. And there's been an issue too with new trustees taking over, and what do you do? And Probate Code section 16049 provides that if the trust says you must comply with the Uniform Prudent Investors Act, you have, as trustee, a reasonable period of time to review the trust assets and make decisions about what to retain and what to sell. So the question then becomes, what is a reasonable period of time? And that is a factually driven analysis, and it will take into account all of the factors. For example, did you have a hard time as trustee getting statements to identify the assets so that you could even review them? What efforts did you make to marshal assets and search for assets? So to evaluate the pros and cons of buying and selling, the trustee really needs to be on top of things and not allow themselves to be paralyzed by the uncertainty of this situation. And then whether you're a new trustee or an existing trustee, Probate Code section 16052 gives you some cover, some measure of protection when managing trust assets. And 16052 provides that a trustee may delegate functions such as in the investment of assets, and as long as they exercise prudence in selecting the agent and conduct a periodic review. So we always tell our trustees, if it requires a license to do something, you should probably use a licensed person to do it. So choose a financial advisor that is experienced, that understands the Uniform Prudent Investors Act, whether or not your trust requires you to comply with that act, because it is good, sound advice, even if you aren't required to comply with the act. And make sure you delegate the investment management to them, but that you also are conducting periodic review. And typically the periodic review is every quarter or twice a year, depending on the complexity of the asset base. But we are telling our trustees now, meet with your financial advisor once a month, document the meeting, take copious notes, date those notes. So if you are later challenged regarding your investment decisions, you will show that you, one, delegated with prudence, you chose a respected licensed professional with experience managing trust assets, and two, that you did not fail in your duty to exercise prudence in the review. So, and the code provides that a trustee won't be liable for the decisions made by the agent if they follow this protocol. So I would really encourage all trustees to take a look at Probate Code Section 16052 and take comfort in the protection that's provided. And there is a roadmap for you to be protected, and your protection results in benefit to the beneficiaries. Because if you're doing everything right, you'll be protected and the beneficiaries will benefit.
And Dawn, that's a really good point, because there are times we've seen documents, I know we all have, drafted at a particular point in time where maybe fixed income seemed appropriate and documents were drafted around that. And now we're in a time where that's not the case. And so it causes a conundrum for people. So you're right. I think looking at each document on its own individually and the beneficiaries, our business isn't easy. There is no turnkey approach that we can use for each of our clients. We really need to create a separate strategy for every trust. It's funny, you talked about starting reading the trust, and I just laughed because a lot of times trustors kind of draft their document, probably sit with you, and then put it in their desk drawer, and they kind of wander off. And now the times have changed and they forget. And so sometimes in their mind, what they think is going to happen and what actually happens is different. So I agree. And on a regular basis, especially right now, people are questioning what's happening. How does this impact me? What does it really look like? Communication is vitally important with your clients.
Okay, next slide. So one of the common questions we have now as trustees are administering estates, and particularly for trustees who stepped in during COVID as a result of the death, is what to do with real estate, and in particular, the family home. And the question that we have received without fail in every estate where we've had someone pass away during COVID is, gosh, when should I sell the family home? Should I sell it now? Or will I be criticized for selling the home in a pandemic because everyone will just assume I received a lower sales price for it? Should I hold on to it until after the pandemic is over? But we have a trust that wasn't well funded and everything else passed by beneficiary designation. So there's not much cash in the trust, and they have a home. Well, if they don't sell the home, how are they going to pay utilities? And there's quite a few acres. So there's weed abatement issues. There's issues with paying insurance, property taxes. What is a trustee to do? And are they going to be criticized for doing it? And that's every trustee's concern, is they want to do the right thing by the beneficiaries, and they don't want to take action that will open themselves up to criticism. So one of the questions they ask is, are values truly lower? And we have had 2 clients die during COVID with taxable estates, and we've been working on the appraisals for the 706, which is, as you all know, the federal estate tax return that's required to be filed within 9 months of date of death for individuals dying in 2020 with more than 11.58 million in assets. And I have been surprised. We haven't gotten the appraisal reports back, but we've been talking with the appraisers regularly, and we are not seeing the discounts we expected. Values are holding firm. What the appraisers are telling us is that people are taking properties off the market rather than discounting value, because the sentiment still is that this economic impact is temporary, and when COVID is gone, things will bounce back. We're very optimistic as a society, and so we're not seeing the depreciation in values. So what is a trustee to do? And in this situation, we tell our trustees that a notice of proposed action is your friend. Under Probate Code Section 16500, a trustee can serve a notice regarding an action they intend to take or not to take. So if the trustee is going to sell property in this environment, we encourage them to serve a notice of proposed action with a copy of the proposed listing agreement attached to it, so all the terms are fully disclosed the notice is served on the beneficiaries. If the beneficiaries do not object within 45 days, they're forever barred from doing so. If someone does object, then a beneficiary or the trustee can petition the court to take the action over the objection. And the nice thing from a litigation perspective, if you're representing a trustee about a notice of proposed action, is that if a beneficiary objects, then the burden of proof at trial shifts to that beneficiary to prove that the proposed action should not be taken. So that's a very important burden shifting tool that you can use. So even if we know someone's going to object, we still serve the notice of proposed action because I want to shift the burden of proof. So there's some strategy involved as well. And in most cases, there's one. You have 8 beneficiaries that want to sell and 1 that doesn't. So you can set the stage for future litigation by serving the notice of proposed action. In addition, I tell clients, don't just use the notice of proposed action for something you intend to do. If you don't intend to do it, use the notice of proposed action. Maybe a trustee has decided that they don't think it's prudent to sell a property. Serve a notice of proposed action saying, I am not going to sell the property until X date, or list it until X date rather, and give a notice of that so that the beneficiaries can't criticize you for your delay in listing the property for sale. It's an effective tool on both sides of the equation. So going back to the valuation issue, it's important if you have a decedent with a taxable estate who is required to file an estate tax return, that because we haven't fully realized the economic impact of the pandemic, it feels like forever not being able to see you in person and talking to a screen instead of talking to people. But it hasn't been forever, and we haven't seen the data has not caught up with the reality that we're all living in. So if you have a 706 that's due, remember the alternate valuation date option. You can elect to have assets valued 6 months after the decedent's date of death rather than on the decedent's date of death. So that is an important tool to bear in mind. And I think in a pandemic where we have the issues that we have, and every day you wake up and one day we're not supposed to wear face masks, the next day we are, we're getting conflicting information on everything. So I think in this situation that it's really important to counsel our trustees to make sure they just get both values. If you have a decedent with a taxable estate, get the date of death value as required, and then also get the alternate valuation date value, because you have no way of guessing or predicting. Just go ahead and have the appraisers update those appraisals. It's not that expensive, and it's good information, and it's good protection for you as trustee. The final issue that we wanted to talk about with estate settlement is, what do you do when you have squatters? When you have the typical, very typical situation, we have a few of these right now, where mom and dad were sick, they were starting to decline. One of the children moves in to help care for the parents. Well, then the parents both pass away, and that child is still living there. And they have a sense of entitlement to be there, that they have a right to be there because they helped their parents when everyone else abandoned them. And it becomes a very emotional issue for the person staying in the property. And it's also their last connection to their parents, being in that home where they all live together. So there's a variety of, swirling emotions surrounding this. And then also the financial realities of, usually the person who moves in with the parents is the person who is struggling financially. It's rare for someone to leave a beautiful home and a great job, high-paying job, to move in and take care of their parents. So you have this convergence of factors that's very difficult. And as you all know, now we have a moratorium on evictions. We're not sure how long that will last and if it will be extended. So what do? We're counseling our trustees to still send the required notices so that there's no waiver of rights with respect to the person living there. They don't obtain squatters' rights. They don't have, there's no passive consent to them being there. We also have our fiduciaries send a notice regarding destruction of property that they will be held liable for anything that is destroyed or damaged in the home. And we give them notice of our right to enter the property and videotape the home in advance so that we can document if they have damaged anything in the home. And then we also are sending notices to the beneficiaries that are refusing to pay rent but continuing to live there, and there isn't a specific gift of the property to them. So that property isn't just theirs. They have a beneficial interest in the property along with other beneficiaries. We're sending notice that the trustee will likely offset their share of the rent against their ultimate distributive share when the final distribution is made. And we are obtaining opinions of the fair market rental value to put them on notice of, you know, the amount of money they're looking at for living there. So those are some things to consider when you have real estate. And as Carly said in the beginning, no one's an expert on COVID. It's only been around for 4 months. So we are here to facilitate discussion. So if you have thoughts or comments, please type them in the chat box, and we're happy for this to be a discussion. I view us today more as facilitators of starting discussions and raising issues rather than presenters today. So Carly, do you have comments? I'm sure you have a lot of experience on the real estate front and have comments on this issue.
Yeah, we've been dealing with the same issues you have and spending a lot of time trying to be creative, trying to work with beneficiaries. What I find, and my minor in psychology comes into play every day that I work, because it is very personal for people. And now with the tension of the pandemic on top of maybe mom and dad passing away, it becomes even more important to have a good communication plan with people and work with them, because they get very, very upset and somewhat frantic, I'd say. So looking at this and your ideas and insistence on notice is something we've employed as well, to make sure that we notice everybody about everything that we're doing, to put all our cards on the table up front and understand where we're going to have problems that we need to devote resources to and where we're not. I mean, in some cases, we had one the other day, we had a business property that was owned. A gentleman owned it half with his partner. The partner just thought that he was going to be able to get, you know, the estate value for the purchase of the property when it's a really valuable property. And so he'd always thought that we didn't need to bid, we didn't need to go through that work. Yet when we in fact sat down and talked and put everything out there to say, this is what we're going to be doing, it became evident. He then realized what the situation was, what our obligation was, and actually began to work with us. So that communication part is really important. Also, I think the squatters on properties is when we've also had issues with, a lot of times too, the other issue we haven't talked about are kind of mental health issues that come up. And a lot of times there's a reason why, especially for us as a corporate trustee, we're named, is to be able to help people's kids that are having a difficult time in the world. So squatters on properties present sometimes unique kinds of things. And your documentation issue is a really good one, because a lot of times what we start to find is abuse of personal property, hoarding, other kinds of things that come into play that then create a huge amount of work once we ultimately can get that property vacant and be able to go to market. So, and also looking at setting aside adequate reserves when we're talking about these kinds of things. I feel like we're spending a lot more time documenting right now, in our case, using outside legal counsel to be able to help us with some of these issues that come up, again, because beneficiaries, it becomes so personal, it's so difficult for some of them to let go of some of these issues. So yeah, I agree with you.
So many issues, and I just wanted to add one final thing before we move to the next slide. Sometimes the squatter can be your friend, and you want to work with them because, as I'm sure you all know, for property insurance, if the home is vacant for more than 6 months, typically is the cutoff, the property insurance goes way up. So we recently had a property that's now been vacant for over 6 months. The property insurance prior to the vacancy while the parents were living there was about $2,000 a year. After 6 months of vacancy, the property insurance premium jumped to $12,000 a year. So insurance companies rate vacant property as higher risk, so that higher risk demands a higher premium. So sometimes you may, there's a lot of competing factors to consider, and it may be helpful for you to work with the squatter if, for example, like Carly said, there's so much property, personal property in the house, it's going to take a long time to go through that property and dispose of it, or, the property may need some repairs before it can be sold. So think about your timeline when you're working with the squatters as well.
Carly and Don,
really
Carly and Don, we
Go ahead,
do have
David.
some questions. We do have some questions from the audience that I thought might be a good time to address real quickly. Let me see if I can get my video back going here, just because it's the perfect time on the subject matter you're addressing. Margaret Fisher, as a council member, wanted just to make sure that folks were aware that even though the full real estate values might not have declined currently, that appraisers are seeing increases in discounts for lack of marketability and control for partial interests in property and partnership LLCs. One comment. The other was from Marilyn Steele, and Marilyn wanted to see if you could address some of the issues with property tax reassessment when the parents are in a care facility prior to death and the trustee is renting the property. Are there problems when the property is over $1 million, and are there exceptions for those in assisted care?
I don't know the answer about if there's anything offered for people that are in assisted living. Dawn, are you aware of anything?
I'm not aware of any exemption for assisted living, but I do know that if someone is temporarily in an assisted living facility, they don't lose their status as the primary residence in terms of the parent-child exclusion. But I don't recall, I haven't had a case like this in a long time, to be honest. And I do remember looking at this quite a while ago. I don't recall, what is defined as a temporary absence from the home and what is not. So that is something I think you'd have to research on a very case-by-case basis, because I do recall quite some time ago when I did look at this, that there was a deep dive into the facts of the absence from the home regarding how that home would be treated for property tax purposes. So I do think the assessor's office has on their website, the assessor recorder's office, they have frequently asked questions, and this may be one of those frequently asked questions. So I would encourage you to take a look. And then they also have a phone number dedicated to trust and estates questions. I haven't tried to get through to that number during the pandemic, but I think that would be a good resource for you as well, because it is so factually driven.
And regarding the tax issue, we haven't, I think it's one of the things we're going to talk about on the next slide, actually. So maybe this is a good segue into the next slide. Perfect.
Great.
So
thanks for the questions, by the way, Margaret and Marilyn. Thank
yes,
you.
thank you.
Yes. And
so
if any
one of the
council
things,
member, oh, sorry, Carly, if any council members know
No,
the
go ahead.
answers to these questions, please pop up in the chat box. We're happy to give you a shout out and an opportunity to share your knowledge.
Right. So one of the things it's interesting is we're anticipating a lot of these changes. We're anticipating changes in values, but I feel like the country just kind of froze for 3 months. And so a lot of things, as I started calling people and asking, what are you seeing in values? What are you seeing in appraisals? You know, have there been any tax, you know, has anybody thought about that yet? And the problem, I think, is it's kind of too early. We factually don't have a lot of change to be able to document the things we think are going to happen. So as we think about it, it's what we think intuitively, which is why I spent some time calling some people. Intuitively, we think these things are going to happen, but in fact, many of them haven't happened yet, just because I think the nation has been paralyzed. So will we look to go to the assessors and get property reappraised? If it's appropriate, yes, but so far we haven't seen values to be able to warrant that yet, but it certainly is on our radar screen. So Dawn started to talk about a lot of these real estate issues, and I wanted to talk about them some more just from the perspective of assets that we continue to manage and trust, and what does the market look like. So first, I wanted to share a story about a couple large national tenants that we have in some of the properties that we hold. It was interesting when COVID hit, the first thing we got from these national companies was a letter of their intention to stop payment. A couple of them were fast food restaurants, and we actually deployed some of our staff out to take photos that the drive-thrus were still perfectly open, working. These people were still earning money. We responded back and said, if you want to negotiate, that's fine, but non-payment's really not an option. And they've all continued to pay. So I think some of the things that we're going to talk about are out of a sense of fear, that people aren't sure what's going to happen. You know, the news certainly ratchets people's fear up. And so it continues to cause people to go to the worst case scenario immediately. Rome is burning and we need to do something about it today. So I think it's important that we put it in that perspective. So working with people, again, that communication, you know, kind of talking them off the ledge, I think is a good way to deal with this. And so what I said before is, what do we know versus what do we think is kind of should be the rule of the day at this point. And it's why we all need to pay attention to what do the market in these assets look like? What are the valuations looking like? Where are we? So the things that we do know, credit has tightened. Lenders are asking for much larger cash deposits in loan to value ratio. Interest rates are lower. So for people who are sitting on a boatload of cash, there probably are going to be great opportunities for them to redeploy assets. But for people that have maybe lost a job, or we're working with beneficiaries that have lost their job, we end up in kind of this perfect storm. The beneficiaries are asking for more money. The assets are becoming less productive in some cases. So as trustee, again, documenting what happens and why you make the decisions you do are vitally important. People may look at this first instead of looking at some other options. We've been a big proponent of the Sba Lending Programs. There are 3 different things that are available through Sba. A number of our clients and their businesses received PPP loan money, and that's been a saving grace for many people. It's allowed them to take a step back, to more objectively look at what their financial situation is. And people have been a little bit more thoughtful. I can remember the early days in the pandemic, I was getting calls of clients going, well, my assets are down 20%. Now what am I going to do? And so I'm pulling up their accounts, looking, going, no, the market, again, the press, the market is down 20% today, but your assets are down, maybe 6 or 7 in a pretty broadly diversified portfolio. So looking at that across the board is really helpful for clients. I wanted to take a minute to talk about residential real estate. It's a pretty interesting market right now, and I wanted to give you some statistics. I give full credit to Barbara Leinenweber, who produces a really nice newsletter on a monthly basis, and she's giving an overview of the La Jolla market, and I think this just kind of gives you a flavor. So what's different now as we look at that? where are things going that we want to make changes or look at different values. And so in May of 2020, in La Jolla, there were 16 sales completed for the month. That was a decrease of 73.8% from the prior year and a decrease of 48.4% from the prior month. May sales were the lowest in the last 3 years. The inventory was 266, and that was up 12% from the prior month and down 14.5% from the prior year. The average sales price per square foot was $752 for attached and detached homes, which was an increase of 0.8%. From April, it was an increase from April of 0.8% and a decrease of 6.4% from May. So you can see that it's like the world is frozen and things aren't happening. So here's was kind of the ray of sunshine, but I think her letter was as of the 26th of June. She was anticipating things might progress more favorably with this next wave. I think we'll have to wait and see. But sales from June 1st to June 26th were 40 versus 77 homes in June of last year. But for July, she was anticipating a stronger market because there were 90 homes in escrow. So I think that gives you a flavor of what people are looking at. It's kind of the unknown. And so it's important to dig in and spend the time to get some facts and basis for your intuition, if you will. The commercial market, I think, is more concerning, but I also think there's less information on commercial. It's an area that I think people anticipate may run into much greater issues as offices trying to decide if they're going to keep office space as workers are working from home, pretty successfully, I might add. So I talked with an owner of a business last week who said basically that their lease was up for renewal. They decided not to renew their lease. They were redeploying their assets for a much smaller property, building out a couple conference rooms and kind of some open space that people could reserve if they wanted to work, anticipating the future, and that they were going to try and continue to work at least half their workforce from home. I know banks, Union Bank has always had our branches open and will continue to do so, but the rest of our working staff is working from home and will continue to do so. At this point, we're not even looking at having people return to work till probably the 1st of September. That would be the earliest. So I think there's a lot of consideration going on right now for what that would look like. Regarding eviction or lack thereof, California, or the federal just extended, there was an eviction, you couldn't evict somebody for 120 days. That just got extended to August 31st for the feds. In the state of California, Gavin Newsom created a state of emergency and said that you cannot evict somebody during the state of emergency. And so that continues, and there is no anticipated date that will be lifted. You can serve tenants 3-day notice. I think, Don, you brought that up. 3-day notice to pay rent or quit notice and file with the court. We have been doing that, and I think it's prudent to do so because once that these emergencies get lifted, I think the line is going to be long for people trying to get solutions for their situation. So, and then beneficiaries living in trust assets, a lot of them have no place to go. We're doing the same thing Don was, a lot of times trying to find a solution for them to be able to continue to stay there and be able to get paid, have it be a producing asset at the same time. So that is a dilemma, again, because of that perfect storm. Many of them may be unemployed. It's interesting that loan holders, what's different now than in 2008 is homeowners, loan holders, have different options that are available to them. we haven't seen the market correct dramatically. So with a lot of these things that have been put in place, you could actually have a longer time to sell your home. And because there is, especially in San Diego County, very limited inventory. I thought it was interesting. People said that since 2016, I believe it is, we haven't built over 10,000 units in San Diego for residential since then. So the inventory is very, very low. So it is giving people different options than they had before in the crash of 2008. I also think that the CARES Act allows people to delay mortgage payments. So you've got a 90-day forbearance that you can apply for, and it can be renewed for up to a year in 90-day increments. The interesting part is that while the forbearance, the people who've applied for forbearance is up to 8.47% of homeowners from 0.25% in early March, many borrowers, supposedly the number I read was 55%, who've applied for forbearance have actually continued to make their payments. So again, an abundance of caution has led people to go to the worst case scenario, think the sky is falling, and try and deploy all these resources that have been made available to them. So I think there are a lot of things going on in this market, and it's important for all of us to check in with each other and say, what do you see happening here? Dawn, I'd love to hear your comments about this.
Sure. I saw a question pop up from Nancy Thornton asking about what type of relief we're seeing trustees give their commercial tenants in this environment. So we represent family offices that have very high concentrations of real estate. And as Carly stated, when the shelter-in-place order first went out and the CARES Act benefits were coming out, we received dozens and dozens of form letters from the national big box tenants saying, we're not paying rent. So what we did was we developed a protocol for responding to those. When we got that letter, we said, thank you very much for your pronouncement, but we have a lease in place, and any adjustments must be negotiated. And to be considered for rent relief, you need to submit the following to us, and we will happily evaluate your request. And what we asked for were year-over-year financials, so we could see if they had in fact been impacted year-over-year. We asked for store hours to see if the hours were shortened. We asked for copies of payroll to see if they were downsizing on staff and having fewer people work. So we sent out dozens of those letters requesting this financial data. We did not get one response. And instead of sending us the financial data, everyone kept paying their rent. We have 100% rent payment currently on the tenants that we received those notices from. We do have one client that we're working with where they have the rent abatement requests. And so where they do, it looks like, we haven't received their financials yet, but from what they're telling us, it looks like they have been impacted given the nature of their businesses. So when we get the financial data, what our client is going to do is tie any rent relief that he grants to the tenants to any relief that he gets from his lender that holds the mortgage on the property. So what he's negotiating right now with his lender is that the lender will permit him to pay 50% of the mortgage for the next 6 months and then scale it back in and up until he's up to full rent a year from now. So if he gets a 50% mortgage abatement, he will give a 50% rent abatement. So it's all tied to data, the type of relief that's requested, and it's all tied to the financial realities of whether or not the property is leveraged. So if any other folks have had any other types or methods for dealing with rent abatement in the commercial sector, we'd be interested to hear what you are doing. But quite honestly, when we sent out the request for all the financial data, We just didn't get requests back. So we haven't had to grapple with this issue very much. We just have one client on the horizon where we will be doing that. So I think it is important when you represent, as attorneys, when you represent fiduciaries, that everything be tied to data, because in fiduciary litigation, it's typically the lack of due diligence that gets trustees in trouble, quite frankly, even more often than the actual decisions that were made, because you can make decisions that weren't entirely successful, but if you had substantial due diligence behind that decision, it's less likely you'll be found liable for a breach of fiduciary duty. So tie everything that you do to data and to process and procedure.
Yep, I agree. Okay, let's go to the next page. So that brings us to personal property. And this is an issue I'm working on right now. So many of you may be in the same place, where we're trying to get back into homes where somebody's passed away in the last 3 to 4 months, deal with personal property so we can put the houses up for sale in many cases. So some of the issues we're looking at is access. So the goal here is to get vendors and beneficiaries access to the house to be able to deal with personal property and be able to move on. So the first is understanding, and our process in our organization is upon notice that we are serving and that there's been a death and the house will be empty at that point, is to get a locksmith there and change the locks on the doors. So we document that, and so that for us starts to be the beginning of the timeline in dealing with personal property with the pandemic, because the coronavirus lasts on physical surfaces. The longest I read was 2 to 3 days on things like stainless steel and plastic. For us, many of these houses now have been sitting empty for 3 months or so, 2 months in some cases. So I don't think we have an issue there, but one of the issues you might talk with your beneficiaries about if they want access to the house is, are they comfortable enough with that, or do they want the house pre-cleaned before they access the house? I think for the vendors we've dealt with, knowing that the house has been empty for that length of time hasn't been a problem for us, but out of an abundance of caution, I think you need to have that conversation. The next is guidelines for the staff as well as for the vendors. So we've been having substantial conversations, making sure everybody understands what the COVID guidelines are, the number of people that we're going to allow in the house at any given point in time, and then kind of you have to have a mask, you have to have gloves. We've got hand sanitizer there. We also give them a notice of what the COVID guidelines are and the requirements are, the same as we give for our employees who are working in our branches right now. So we want them to acknowledge to us that they've read them, that they understand what the issues are, and they still want access to the house. So some of the things we deal with in looking at that and the timeline we create, the first off is, if we don't need people there, then we should do everything we can to prevent them from being there. So in dealing with personal property, our first step after getting the locks changed, and now we're going back in, is inventory and valuation. So we're making sure that the inventory includes photos of everything. So we're filming, we're taking photos, and the valuation people are coming in. That's vitally important to us, because if we can use those photos to provide to the beneficiaries so that they can make decisions about what things they want, what items they want, rather than coming into the house, that is a better solution, I think. There are some cases that just won't work. For some beneficiaries, it's just sentimental, personal. They want to be back in that house one last time. They want to see, you know, where they grew up. It's important. So again, we have a disclosure that goes to them that says, you understand all these things and you assume the risk and liability that you're going to go into this house. So that's important. And then next is, once we get the valuation completed and the inventory, then it becomes disposal of more the non-valuable personal property. Again, do we want to go the estate sale route, which a lot of times people would have used in the past, or what we've seen lately is we're going more to private sales, again, off those videos or photos, or pulling those items out of the house and going to auction at their location. That leaves us then with the things nobody wants. Charities are now open. We've been actually calling charities and making appointments to bring assets to them. I think that works a little better. Some of them have opened up and gotten overwhelmed with donations. I think a lot of people have been cleaning out their houses in their spare time when they've been sequestered at home. So some of them thought they were open and then have closed a little bit. So kind of calling ahead probably is a wise idea. And then off to the dump with what's left. Dumps during COVID were closed. They have now reopened, and that seems to be working better. We also have our staff review guidelines to make sure they understand everything that's going on there. And so it's, again, staff, vendors, beneficiaries, making sure everybody's protected, everybody's safe, and everybody understands what needs to happen in dealing with these issues. So those are the kinds of things we have been putting in place. Don, you had referred us to the California Realtors Association site. They have added a number of documents to their agreements just to allow realtors back into sell homes, but they've got some good language in their documents that is very helpful, I think. So, Don, comments from you?
No, I think you have an excellent process and procedure, and I think this is just a good reminder, hearing Carly speak for us transactional attorneys, the choice of trustee is so critical. When you see the process and procedure that Union Bank and other corporate fiduciaries have in place and licensed professional fiduciaries, and we are just really counseling our clients to really think long and hard before naming a family member as a trustee, because in times of crisis, it's when you see the value of all of this process and procedure and everything that is available when you have a professional fiduciary in place.
You bring up a good point, and it's one of the things we didn't do a slide on, but there have been certain situations where clients, elderly clients who have tried to be very self-sufficient, found that now not being able to get out caused them a lot of problems about being able to get food, because they may not be as computer literate as what might be necessary to order food online, as an example, or pay people that help them, things like that, couldn't get to the bank. So we really have challenged our staff to try and find the most creative solutions possible. And in some cases have worked to, even on an interim basis, pick up and do the routine kind of things we do for other clients, just simply like bill pay, which some clients found now to not be possible for them. So those kinds of things have been important. I also think things like preloaded debit cards, things like that, to be able to allow support people to help people who are kind of stuck at home or stuck in a location that their ability to get the services they need is really hampered. So those things all have become vitally important.
Okay, next slide.
Back to you, Dawn.
Okay, all right, so I think we can go on to the next slide. We're going to talk briefly about Emergency Rule 9. Carly, did you have anything further on this? I think you covered everything on this slide.
I think we did too.
Okay,
we kind of built it in other places. Yep.
Right.
Perfect.
Okay.
Thank you.
So let's go on to the next slide, Ollie. We're going to talk about Emergency Rule 9, the statute of limitations and its tolling. And so usually when we start talking about the tolling of statute of limitations, the transactional attorneys and financial advisors and fiduciaries start thinking about what they have to do next when they leave this call. But this is a time when the tolling of the statute of limitations is so critically important for the folks on the transactional side to be aware of, because it will change the advice that you give your clients. If you're an attorney advising trustees in the administration of a trust, if you are a trustee, it will change when you will distribute assets and when you will take certain actions. And as a financial advisor, I think it's so important for you to be aware of this, so that if you have clients who are trustees, you can ask them if they have considered this tolling when they call you to talk about distributing assets to the beneficiaries. So this is a really important issue for not only civil litigators, but also for everyone on the transactional side. So the court issued Emergency Rule 9, and at the end I have a slide that summarizes the iterations of the rule for your historical reference, because sometimes I hear things and I think, oh wait, no, it was different. Well, that was before the most recent change. So I wanted you to see the history, but we won't go over that in the interest of time. So what Emergency Rule 9 does is it tolls the statute of limitations for causes of action or actions where the statute of limitations is over 180 days. So this is where the period of limitations is 181 days or more. And so the statute is tolled from April 6 until October 1, 2020. So what that means is you have your normal statute of limitations, which is the period in which you must do or not do something. And then the tolling of the statute means the statute literally just stops running during that time period. So the statute of limitations stops running from April 6, 2020 to October 1, 2020 for statutes that have limitations period of 181 days or more. Secondly, if the period of limitations is 180 days or less, then the statute is tolled from April 6 to August 3rd. So how does this impact transactional folks? I think it impacts us most in two areas, and bear in mind this tolling applies to all civil causes of action. But what I want to focus on are the two areas where I think it impacts us the most. And that is with respect to Probate Code 16061.7 notices, and with respect to the notice that you must object to an accounting within 180 days or less. So Ollie, if you'd go to the next slide, please. So as we all know, Probate Code section 16061.7 requires a trustee to serve a notice on all trust beneficiaries, heirs at law, and the California Attorney General in cases involving charities within 60 days of a revocable trust becoming irrevocable, or a change of trustee of an irrevocable trust, or the lapse of certain powers of appointment. And I would just like to remind everyone that 16061.7 does apply to lapses of powers of appointment. And this is just kind of a little sidebar, because this is most often where I see trustees fail to serve this notice. Trustees most frequently think of the 16061.7 notice as the notice that must be served on heirs and beneficiaries when someone dies and their revocable trust becomes irrevocable. While that is true, there are three circumstances that require the service of this notice, and I just wanted to remind you of that. So if the notice is served because the revocable trust became irrevocable, then we must include a warning similar to that found in section 16061.8. This warning is also in 16061.7, but I wanted to share this with you because it had the timelines in it. And that warning says that if you receive a 16061.7 notice, you must bring an action to contest the trust if you're going to do so no more than 120 days from the date the notification was served on you, or 60 days from the date on which you received a copy of the terms of the trust, whichever is later. So as a practical matter in our firm, we always serve a copy of the terms of the trust with the 16061.7 notice, so that an heir or beneficiary has a maximum of 120 days to contest, and they cannot extend that period to contest by on the 119th day requesting a copy of the terms of the trust, and they extend it now to 180 days. So if you served a 16061.7 notice, for example, on March 1st, when does the period to contest end in light of Emergency Rule 9? So with the example of service on March 1st, the normal period to contest would be 120 days from March 1st, right? So that would be June 29th. And because the period to contest falls after April 6th, when the statute's told, when 16061.7 is told, we now have to recompute that date. June 29th is no longer the date on which someone must contest the trust. So we look at how many days on the statute ran before the tolling. So if the notice was served on March 1st, the statute, because it's 180 days or less, so we're dealing with Section B of Emergency Rule 9. So from March 1st to April 6th, the day the statute began to toll, 33 days had lapsed. So you get credit for those 33 days. So your statutory period is 120 days. Subtract from that the 33 days where the statute actually ran because no tolling was in effect. That means you have 87 days remaining on the statute. Well, not one of those 87 days can run for the period April 6th to August 3rd. So you have to then add to August 4th because the statute is tolled through August 3rd. So the first day the statute begins to run again is August 4th. So you take the 87 days that did not run and were tolled, you add that to August 4th, and you have a new date to contest the trust of October 30th, 2020. And I know that's an awful lot of math for attorneys on any day, because I know I went to law school because I can only deal in words, not numbers. So it's confusing, but I'm happy to talk with anyone about this. So, but the point is now, if you are advising a trustee and you're telling them the statute runs on June 29th, so on June 30th, feel free to make a preliminary distribution because you haven't had anyone contest the trust, your trustee is going to be in trouble if someone contests because they actually have until October 30th to contest the trust because of the impact of the tolling of Emergency Rule 9. So this is one of those really unique times in our practice history where rules that typically are for litigators can really impact the advice and the activities of the people on the transactional side. The tolling will also apply in our situation. We can go to the next slide, Ollie, to accountings. Now, as you know, there are many trusts that have provisions that say if a beneficiary does not object to an accounting with X number of days, then they are forever barred from doing so, and the accounting is deemed approved, and this approval inures to the heirs, beneficiaries, and assigns of the beneficiary who failed to object in the 180-day period. So if you serve an accounting with this probate code section 16461C notice on it regarding the 180 days to object to the accounting, this statute is similarly tolled. So many prudent trustees will not make distributions until they know if the accounting is settled. And because after all, how can you really distribute if the accounting is an open issue and you don't know if someone's going to contest it and therefore assets be eroded by costs of defense or other issues? So the same tolling applies to this section. So I wanted to bring this to your attention because I think it's just critical that we all be aware of it because it will change the advice that we give our trustee clients as attorneys and as trustees. It will change the timing of the actions that you take. And before we move on from Emergency Rule 9, Roberta sent out a notice yesterday from the San Diego County Assessor Recorder's Office that announced that they are now accepting electronic recordings. So Bill is going to circulate that notice later, but this is so important. I was so excited to see this. Please be looking for this notice. It's been really frustrating to mail in documents for recording, and we sent something in the end of March. We got it back, I think it was last week, recorded. And I really empathize with those in the recorder's office. We've been talking with them to arrange some presentations, and they just talked about literally the mountains of mail that they came back to. And so please be looking for that notice as well. And Carly, do you have anything on Emergency Rule 9 that you would like to add?
No, it is food for thought because it affects everything that we do. And it's, in a time where beneficiaries may want to speed up the process, not slow it down because they're anxious to get the money because maybe they've lost their job. So it puts trustees in a doubly difficult situation. So I think it's one that we need to be, again, over communicating to the beneficiaries that there is an issue here. It's meant in an abundance of caution for them, but they may perceive it as harmful to them. So that becomes an issue.
Yes, and for our trustee clients, we are actually sending a letter to all of the beneficiaries explaining this, that in ordinary course, in the example that we use, we would have been able to consider making a preliminary distribution in June. Now that has been delayed till November because of Emergency Rule 9, and we quote the rule. And it's been really great to be proactive, and we get replies thanking us for letting them know rather than angry beneficiaries when they just see nothing happening. And I think, a trustee I often think of as Mary Poppins. They must be practically perfect in every respect. And so whether you are doing something wrong as a trustee or just perceived to be doing something wrong, that's an issue. And I find it very rare, very, very rare. Particularly in professional trustees, institutional or licensed professional fiduciaries. I can honestly say I haven't represented a trustee who has willfully neglected their duties. But in any event, perception is often reality. And as Carly did such a great job of pointing out, people's heightened fear and anxiety in this environment may lead some to assume the worst when things are silent. So what we have been doing during this time where anxiety is high is we've been really working on over communicating and that there not be huge blocks of silence. And we actually just sent out a round of letters to beneficiaries that said, here are all the various statute of limitations that we were waiting for. So you're going to not hear from us for probably 2 or 3 months because we're just in a holding pattern until these various statutes lapse. And so don't assume our silence means no one's working on your behalf. Our job now is to sit tight and see if we receive any notice of tax audit, if the Department of Health Services makes a claim, and if anyone contests the trust. So the over communication has been really beneficial.
I think it's kind of causing a backlog. The second half of the year is going to probably be pretty painful just because a lot of these things are getting pushed back further. I've finally seen some auditor responses on some 706 audits that were way overdue. So people are kind of now finally starting to get back to work. I had told Don that we normally get tax identification numbers for new trusts that we are setting up in bulk. The IRS office in Cincinnati reopened about 2 weeks ago, so we're finally able to get tax ID numbers, which we couldn't get for some time. So there have been a lot of things like that that hold people up. Dawn, I don't know if you want to talk about court dates that you've seen. Most of the court actions we've had have been postponed probably at least 3 times, and most of them are getting pushed into next year at this point.
Yes, we are seeing things being pushed back, but quite frankly, not in San Diego, not as much as I had thought. We had a trial that was scheduled to go the first week of June. It was now rescheduled till the first week of October, which for me didn't seem that long, quite frankly, because we have a number of cases in LA, and prior to COVID, you wouldn't get a trial date that quickly. You wouldn't even get your first hearing date that quickly. So we're accustomed to the LA lag in setting hearing dates. So for us, it feels like, wow, things are being set very, very quickly. But for the clients, they certainly don't feel that way. When a client is all geared up and ready in their mind for resolution sometime in June, and now they're being told they have to wait till October for resolution, they get deal fatigue. They get, they're exhausted. They've been going through this very emotional process for them for a long time to get to trial. And by that point, people are usually just say, I don't care what the outcome is at this point. I just want it to be over. Well, now they're told, well, I know you just ran 5 miles, but you have to run another 20. And they just look at you in astonishment. So it's, again, what Carly said, being sensitive to the fact that, to us, oh, this is great. We got an October trial date. That's wonderful. And clients don't necessarily see it that way. So how we communicate all of these changes is so important. And then one thing to be aware of, for example, with this October trial date that we had, the court sent out notice. And of course, on the notice, it lists everybody that's served. I was talking to counsel with whom my client is aligned, and we received our notice in May, the mid-May, and counsel had not received notice yet. So he did not know the trial date was moved to October. So what we are doing now, when we receive notice of a continued hearing or trial date, we're just forwarding that to all the attorneys on our service list so that we make sure that everybody stays informed. It's to no advantage to dupe people, or we just don't practice like that to withhold that type of information. But we are seeing more and more that some people are getting the notices and others are not, even though they are listed as having received the notice. So please be mindful of that. And then we have our paralegal check the docket twice a week on all of our pending matters, because there are many notices we haven't received. But for our paralegal checking the docket, we would not know of our new hearing date. So please be vigilant on that front as well.
I think that's all really good and important to know. Other things I've seen is people seem to be more willing to go to mediation. Mediation seems to have been open longer, been more effective, things that probably would have gone to court otherwise. So I have seen clients, when explained the alternatives, choose that route, which I'm not sure they would have otherwise. So I don't know if you've seen that as well.
Yes, and we have been even holding, virtual mediations, quite frankly, without a mediator. And one of the attorneys simply takes on the role of coordinating the conference call for a set date. And that's been terrific. And quite often it's common in our practice area to file a petition to approve a settlement agreement. But now with getting in the back of the line, because all the matters that were set and continued are in the front of the line, if you're a new matter at this point, you're in the back of the line. So you're not going to be heard for a few months. And once people finally settle, they want to distribute. So in cases where we don't have no issues regarding unborn or minor beneficiaries that need to be bound by an order on a petition to approve the settlement agreement, where all parties can sign, we are now filing a stipulation in order regarding the settlement. And so you don't need a hearing for that. You just simply submit it to the judge where your case was assigned, and the judge will sign off on it. And we're getting those stipulation and orders back at record speed. I think the court is really excited to clear their docket of the cases. So we're getting those back very, very quickly. Sometimes I think the last one came back in a week. So you have your order and you can proceed with implementing the settlement agreement. So if anyone wants a sample of that, I have several of those that we have filed, and they're a matter of public record, and I'm happy to email it to you so you can see the format and not make you pay the $7 to download it. So just shoot me an email if you would like a sample of that.
Good. Well, I think that brings us to the end for questions. So people have been asking via chat all along. So please let us know if you have other additional questions. David, it sounds like it's back to you.
Yes, it looks like we've answered everybody's questions. Yeah, please let us know if you have additional questions, and the panelists will be pleased to answer it while we're here or offline when the presentation is over. Carly and Don, thanks so much. That was terrific information and so topical considering what we've got going on today. So really appreciate that wonderful information, very practical. Before we leave this morning, just wanted to let everybody know of 3 very quick reminders. 1, trifectas. So please go ahead and email Pete Tentler or Bill Super if you'd like to be in a trifecta and if you would be willing to be a leader. The second is mark your calendars for August 7th for the next Estate Planning Council meeting featuring Mark Morris and Phil Sullivan. And lastly, be sure to mark your calendars and spread the word about September 1st, Natalie Choate's 3-hour IRA, in-depth IRA planning presentation. With that, it looks like we do have one Q&A here. Let's see if we can get this real quickly before 9 o'clock. Buddy Thomas asked, what courts are open and what courts are not?
So all of the courts in Southern California are now open, but that doesn't mean you can go there. So the courts are now setting matters for hearing and trial, but all appearances are either via court call in San Diego County, via court call via video, or telephonically. And in San Diego County, they have announced that they will not be permitting people to enter the courthouse for the rest of this year. So it's going to be really interesting. I've never conducted a video trial before. So I have to say, I feel like a first-year associate with the nerves for doing something totally different. So we'll see how that one goes. The video hearings, you know, you have the option of appearing by video or telephonically. I opt for video. You have to read the judge when you're arguing. If you're just speaking to, you know, the wall, you're going to not catch on to where the judge wants you to go. So I encourage everybody, court call video is pretty horrible. Quite honestly, it's not as easy to use and not as efficient as Zoom. But it's better. That's the only option we have in San Diego Superior Probate Division. The other divisions do have other options because they do not have a standing contract with court call. Because our probate division has a standing contract with court call, they are not able to permit Microsoft Teams or Zoom, but other civil departments are. So we're also learning that the odds of getting a jury trial in San Diego County on a civil matter are almost 0 because the California Constitution and law requires the prioritization of the criminal matters and the time frame within which criminal matters must be brought. So in our practice area, that means elder financial abuse claims primarily, where you're entitled to a jury trial. And there's a couple other small, you know, exceptions to bench trials. But think long and hard as a practitioner before demanding a jury trial on some of the claims that are eligible for that, because it's highly unlikely that any jury will be, well, they won't be impaneled this year because they're not allowing people into the courthouse for these civil matters. So think about that as well when you are planning your case.
That's great. That's great advice. And thanks for that. Thanks for that question, buddy. Really appreciate it. We've got our experts for another minute. So if anybody has any other questions, this is a terrific time to ask. And if we don't have any other questions, I did want to also extend an extra thanks again to Jewish Community Foundation and Ollie. Thanks again for running our Zoom meetings. And with that, I don't see any other questions. With that, thanks again, everybody, for attending. Carly, Dawn, Ollie, thank you. And we look forward to seeing everybody next month.
Thank you, David.
Stay safe and healthy.
Bye, everybody.
Thanks, David. Bye.
Thank you.